Welcome to Legalized Negligence, take 5, I think it is now, where we talk about Florida Statute 768.21, subsection 8. And today, Travis and I are going to talk a little bit about some comments that Senator Yarborough made during the judiciary hearing on the 22nd. I'm going to jump right into it and share a couple of little videos with you. And let me get this up. Travis, tell me when that pops up and I'll start the video. Right. Okay. In this first one, we're going to hear Senator Yarborough talk about injustice.
Senators, like many of you at your local delegation meetings here at the Capitol and/or through phone calls and emails, I've learned about and listened to the stories of a number of individuals who were impacted by the wrongful death exception currently in Statute 768-21-8 that was enacted in 1990. In full respectful candor, let me be clear that the sole reason I have placed this issue in front of us is because while an effort to reduce medical malpractice insurance premiums at the time was a worthy pursuit, implementing a ban on certain individuals to where they could not and still cannot access their judicial system to plead their case is a clear injustice.
Okay, he's talking about an injustice.
And Senators, like many of you at your local delegation meetings here at the
he's talking about an injustice that has been going on for 34 years. And I know you've already heard me say this once because we've had trouble getting this recording going today, but bear with me again while I give this example. Yes, your inalienable rights can be violated from time to time. And depending on the severity of the emergency and which right is being violated, the government does have the authority to do that. And an example that I used is imagine waking up or imagine sitting on the beach and all of a sudden the sun comes up and you see all these Russian submarines and aircraft carriers and battleships. Would you agree that the government has the right or the authority to infringe upon your right to deal with that situation that's sitting on the horizon? Of course they do. Well, in 1990, the government perceived a problem with doctors leaving the state because their malpractice premiums were too high. And they decided to deal with that problem by limiting certain people's ability to sue doctors for their malpractice. That should have only, if they thought that was their only remedy, it should have only gone on for a brief period of time until they could look at it and determine whether or not that solved the issue. But 34 years is insane for this law to have stayed in place. And Senator Yarborough just recognized that this injustice has been going on for 34 years. Now, the next video that I'm going to play for you, Senator Yarborough is going to talk about deference. And I want you to pay close attention to what he says here in this clip. And I'm probably going to play this clip twice.
The Florida Supreme Court did acknowledge that, quote, the legislature has the final word on declarations on public policy, and the courts are bound to give great weight to legislative determinations of facts. Further, legislative determinations of public purpose and facts are presumed correct and entitled to deference unless clearly erroneous, which we've talked about today. Because the legislature's factual and policy findings are presumed correct, there's been no showing that the findings in the instant case are clearly erroneous. We hold that the legislature has shown an overpowering public necessity exists.
Okay. Could you hear that all right, Travis?
I could.
Okay. Hey, notice he's saying that the legislature's law that they passed in 1990 was presumed correct. The reason that they passed the law was presumed by the courts to be correct. And he spoke about deference. Travis, do you think I need to play that a second time, or did it come through?
All right. I would do it just to be sure, people didn't miss the opportunity.
Okay. Yeah, pay close attention to when he speaks about deference, because what he's talking about is the courts show deference to the legislature. In other words, they don't question them. They just trust that what the legislature did was the correct thing to do.
The Florida Supreme Court did acknowledge that, quote, the legislature has the final word on declarations on public policy, and the courts are bound to give great weight to legislative determinations of facts. Further, legislative determinations of public purpose and facts are presumed correct and entitled to deference unless clearly erroneous, which we've talked about today. Because the legislature's factual and policy findings are presumed correct, there's been no showing that the findings in the instant case are clearly erroneous. We hold that the legislature has shown an overpowering public necessity exists. And then last.
Okay. So
that takes me off. What he says, what the legislature finds is presumed correct. I'm like, hold it. Don't you think you'd have to prove that they're correct?
Yeah, and that's what we're about to talk about. That's the part that we're about to discuss. The next clip that I'm going to play is going to be a law professor named Randy Barnett, and he is going to talk about deference and specifically double deference. And this one's a little bit longer than those, but it's very important that you understand what Professor Barnett has to say.
Let me talk about the problem of double deference, because in practice, deference to legislatures sounds okay. And in principle, I myself don't have a problem with what is sometimes referred to as deferring to the policy judgments of legislatures. I think that's entirely okay. Legislatures do engage in policy. The judges generally should not engage. They should not engage in policy. Strike the generally. They should not engage in policy. That's not their job. Their job is to assess constitutionality. It's not to choose wise policy over bad policies. That's not their job. But in practice, what deference to the legislature then is switched to mean is deference to the legislative assessment that a law is within its powers. That is, deference to the legislature's judgment that a law is constitutional. Now, that's not something I think judges should defer to. They are an equal branch of the federal government, and they're entitled to their own opinion about whether a law is constitutional. And there's no reason why the legislature should get two bites at the apple and have exclusive control over the scope of its own powers. That would be to not respect the rights retained by the people. But what really happens in this town, everywhere, when this happens, and this is, I would defy anyone to say that this isn't what happens, and that is when the federal courts or when the Supreme Court defers to Congress and says, no, we defer to you and your judgment of constitutionality. What happens when you go across the street and on the Hill and ask a legislator whether what they're doing is constitutional? What answer do you get? The answer that you get every single time is, what I'm doing is constitutional because the courts will uphold me. What we're doing is constitutional because the courts will uphold me. Well, if the doctrine is that the courts will uphold you because they are deferring to your judgment of constitutionality, and then you say a measure is constitutional because the courts will uphold me, then this is what's going on. And this is what's being lost in the process. You have each side pointing the finger at the other side. That's not my job to say whether it's constitutional, that's their job. And each side does that. This completely drops from the process. And as a result of the doctrine of double deference, we end up having lost very important clauses of the written Constitution that is meant to secure the liberties of the people, the sovereign people, each and every one of us.
Couldn't have said it better myself.
Yep. Yeah, we basically have a two-party government, legislative and executive, because the judiciary has given up their power to the legislative.
Yeah, and that's the problem here. And what happened is that when the cases, and like I say, there's been several of them over the last 34 years that have made it to the Florida Supreme Court. And each time the court says, in the, this is a paraphrase, but what they're saying is, we trust that the legislator did the right thing. And so we're not going to overrule what they did. And of course, the legislature, if you ask them, like Professor Barnett said, the legislature is going to say, of course it's constitutional. Why? Well, because the Supreme Court is going to say that they defer to us on its constitutionality. Now, here's where we get into something called rational basis theory. Basically, it is when a court is going to determine the constitutionality of a law, the Supreme Court has used a three-pronged test. There's the lowest level of scrutiny, which is called rational basis. There is the middle level, which is intermediate scrutiny. And then there's the third level, which is strict scrutiny. These came about, started in, if I remember right, it was 1938. There was a case called Caroline Products versus somebody, I can't remember who, but that started the ball rolling on this. And then later on, I think it was in the 1950s, there was a case, Williamson versus Lee Optical, that the rational basis strict scrutiny test finally got applied, and they've been using it ever since. So I'm going to play a clip of Yarborough talking about the rationality of subsection 8. And that's what he's discussing here, is rational basis.
And then lastly, again, with regard to the constitutional aspect, state and federal courts around the country have addressed the issue, and many have determined that the caps are constitutional and rationally related to the important state interest of bringing down the cost of medical malpractice insurance and facilitating the availability of affordable health care.
Okay, I want to play that one more time, because he said the courts determined that the law was rationally related to bringing down the cost of malpractice insurance.
And then lastly, again, with regard to the constitutional aspect, state and federal courts around the country have addressed the issue, and many have determined that the caps are constitutional and rationally related to the important state interest of bringing down the cost of medical malpractice insurance and facilitating the availability of affordable health care. We have.
Okay, that's the end of that. Let me close this video and stop my share. And then I am going to pull up a brief video that explains rational basis. Let me get my Zoom back up so I can share that. Share screen. Okay, can you see my black screen there, Travis?
I can.
Okay, this is just under 4 minutes, but it's a very good explanation of this.
In this video, we will introduce the rational basis, intermediate scrutiny, and strict scrutiny tests. The rational basis, intermediate scrutiny, and strict scrutiny tests are all tests that courts apply to determine constitutionality. But keep in mind, there are other tests. Courts apply these tests to determine whether a law or government activity is constitutional or not. For each test, the courts apply 2 factors. First, what was the government's purpose in creating the law? And second, how does the law accomplish this purpose?
I'm going to pause it there. So let's ask ourselves that question about subsection 8. What was the purpose in them creating it? To bring down the cost of medical malpractice insurance for doctors, correct?
Correct.
And then how does the law accomplish this purpose? Well, no matter how you look at it, basically it comes down to this. If we prevent a certain number of people from being able to sue a doctor for negligence, then there aren't as many payouts, so his premiums will come down. They never address the negligence itself. They simply address, how do we get his payments down? It would be the same as me saying, you know, my car insurance is really going up. I keep getting in these wrecks. And then a government saying, well, then, you know, we just won't arrest you anymore for all the wrecks you're getting into, or we won't cite you. And that way your car insurance will come down. Well, that's just ignoring the problem. You know, the problem is the malpractice. It's the negligence. And that's what they've been doing, is they ignore the malpractice, but they accomplish their goal, they claim, by preventing people from being able to sue. So there aren't as many payouts. Now the doctor's premiums go down. However, they say that the crisis still continues. So in 34 years, subsection 8 didn't cure the problem. They still say that doctors are leaving the state. So it wasn't the malpractice premiums being so high that caused doctors to leave the state. They must be leaving for another reason. So I'm going to continue on with this.
So our first factor asks, why did the government pass the law? How critical was the purpose? Was it for a legitimate government purpose, an important purpose, or was it for a compelling government purpose? It's easiest for a court to conclude that a law had a legitimate purpose, but it's significantly harder for the government to demonstrate that a law had an important purpose, and it's most difficult for the government to demonstrate that a law had a compelling government purpose. Our next factor is, what is the relationship between the law and the government's purpose? How does the law achieve the purpose? At the easiest level, we only need a rational relationship between the law and the government's purpose.
And that's what Yarborough said a minute ago, that there was a rational relationship between preventing certain people from being able to file a suit and holding the doctor accountable by suing him for non-economic and economic damages. So there, I just keep trying to tie this back to what Yarborough said.
More difficult is to show that there is a substantial relationship between the law and the government's purpose. And most difficult is to show that the law is narrowly tailored, or the least restrictive way to achieve the government's purpose. And now we have our three tests. The rational basis test is the easiest challenge for the government because the party challenging the law must show that there is no rational relationship between the law and a legitimate government purpose. The intermediate scrutiny test requires the government to demonstrate that there is a substantial relationship between the law and an important government purpose. Most difficult for the government is the strict scrutiny test, which requires the government to demonstrate that the law has a compelling purpose and that the law is narrowly tailored or the least restrictive way to achieve that compelling purpose.
Okay, so look where we went. We went from the plaintiff, which would have been us, having to prove that there was not a rational relationship. And you're going to hear this guy say in a minute that anybody could come up with a rationality how this relates to that. And when you get to strict scrutiny, now suddenly you turn that around and the government has to prove. So on the lowest level, the easiest one for the government to win, the people have to prove that it's not rationally related. But on the most strict level, the government would have to prove, the legislature would have to prove that the law was compelling. Any questions before I continue, Travis?
No questions.
Okay.
To summarize, the rational basis, intermediate scrutiny, and strict scrutiny tests are three tests that courts commonly apply to determine whether a law is constitutional or not. The rational basis test is the easiest test for the government because the party challenging the law must show that there is no rational relationship between the law and a legitimate government purpose. The strict scrutiny test is the most challenging test for the government because the government must show that the law is the least restrictive way to achieve a compelling government purpose.
Okay.
To me, the fix is the test for the law. You know, they
Say that
need to have the cause for the purpose as part of the solution, you know, for the law that they enact. That should be a requirement. Does the law address the reason for the law, the causality of the law? And that's not part of the test currently.
Yeah, it's, you know, this is a thing that, you know, we were talking with Jackie yesterday about this, and it's like, as far as I can tell, the legislature is just going by data that the insurance industry is supplying to it to determine whether or not malpractice premiums are too high and what caused that to happen. You know, now they're gonna bring up the task force study that was done in 1988, and you and I have already read that and found that the legislature, before passing subsection 8 in 1990, they didn't follow some of the recommendations, and some of the ones they did really only took the data that the insurance industry gave to the task force to look at. You know, I think it should be clear, the people have been putting up with this for 34 years. And I think the government needs, and when I say the government in this instance, I mean the legislature, really needs to find out exactly what's happening, because what they don't address is, you know, the first two easy ones is, number one, are malpractice premiums too high? Number two, are doctors leaving the state if they are too high? And then you get to, well, what's causing them to be too high? And they're only willing to look at one problem, and that's the number of payouts. They call them these extravagant payouts. But there's a lot of other reasons, and you and I have talked about maybe the pool of payers, if that were larger and the insurance companies had more in their reserves, you know, it wouldn't put them in such a bind when doctors commit malpractice. And what I mean by that is, you know, there are doctors who don't carry insurance in Florida, and they have to post a little sign in their office that says that. But what if you increase the number of doctors that had to carry insurance? Maybe the reserves that the insurance company sets aside would be higher, and they wouldn't have a problem now.
Yeah, there should be a law that requires them to adjust the premiums such that they meet the actuarial needs, because in that MLM report, it shows that they're not doing that.
Yeah, and like you pointed out, when you looked at that, there is one company that is charging, gosh, was it like 4 or 5 times more than what was actually necessary? And those are the numbers we think that the legislature is being shown. And that particular company happens to be owned by a bunch of doctors. It's called the Doctors Company. You know, that insurance company is owned by doctors. So,
and it's their numbers that are being given to the legislature.
Yeah, instead of looking at the other ones where they were lower and go, well, maybe the premiums aren't as high as we're being told. Like you mentioned yesterday, why don't they throw out the highest and the lowest and go with an average and then make a determination? But the fact is, the people's rights have been infringed upon for 34 years based on what I believe is erroneous information. They're only being shown some of it. They're not being shown all of it. You know, and I think the legislature has a duty to look into all aspects of it. Whether you're going to deny us access to the civil courts to be able to file a suit and recover non-economic damages, or if you're going to put a cap on those non-economic damages, you owe us a duty to make sure that it's the least restrictive and for the shortest amount of time. You know,
how do you go about getting a finding that the data is erroneous?
Well, where I came to that determination was by reading some studies by people who actually studied it, not only in Florida, but across the country.
Right, but how do you compel that finding upon the legislature?
Well, I sent that information to several people in the legislature, Yarborough, Book. Um, I'm trying to think of I don't think I sent it to Lopez. I'm trying to remember the other one in the House that I sent it to, but I can't make them
Roach?
read it.
Was it
No,
Roach?
no, it wasn't Roach. It was the one who signed on to Lopez's bill. Um, I can't think of his name right now. Bertrand. That's who it was. I believe I sent it to Bertrand, but I can't make them read it. I can send it to them. I sent it to them in a PDF. I sent it to them. I sent sections of it in the actual email. I suggested the books, and I did that back in October. I started doing it in October, thinking that that would give them a bare minimum of 2 months before they went into session. And maybe one of them would go onto Amazon and buy the book. I also gave them links that they could just click on the link and go to some of the studies and read it, and, you could say, well, how do you know that study's right? Well, at least the legislator would then have something to go and argue with the insurance lobbies and say, well, your data says this, yet I've looked at these studies that say something different. Now, help me understand the discrepancy. It's up to the legislators to do that. I can't make them do that. I can't make the insurance company admit to the legislator that they're only showing certain data. But I know if it's available to me, it's available to them. They just have to have a willingness to look for it.
How do you get that determination of erroneous?
don't
It'll have to go to court, and then I guess the court will have to have a finding. We'll have to prove it to the justices.
I don't want to start any kind of conspiracy theory, but at some point you start going, I've handed you this information. I've done everything but tie you to a chair and read it to you. So at some point I got to wonder what's stopping you from addressing this. And the only thing that comes to mind is I don't have the kind of campaign finance money to put in their, war chest like the insurance company or the insurance lobbies do. I hate being like that, but I can't think of any other reason that they would be willing to look at what the insurance company provides to them versus look at what I've been providing or other people have been providing, or that they should have been investigating on their own. If I was a legislator and I had felt like I had a duty to my constituents, then it would be my obligation to go out and search out this information, But I would look at an insurance lobbyist and say, you've been providing this information to us since the mid 1980s, and I've got some questions about it. I need you to answer these questions for me because the people have suffered for 34 years. But that's just me. Nobody elected me to office. So, but I just wanted to do a brief podcast and put some information out there for people to think about, and hopefully it will spur them to go do some research on their own and look into it on their own, and then to get in touch with their legislators. We're almost half a month. When did they go into session? On the 9th? We're a month into it. They got, is it about another month before?
I think it's 90 days.
90 days. Come on, there's a little bit of time here. It's time for the people to get busy and do our job of helping them see our side of the story. So sorry I'm ranting so much, Travis.
No, I enjoy it sometimes.
Sometimes
You speak the truth. You speak the truth. It's
well,
a good rant.
I just what's got me concerned is that they have included this OPAGA part of, where OPAGA is going to do a study and determine whether or not caps have, helped out at all. And, what that said, and they've given them until the 31st of December, 2029 to report back. So it makes me wonder, if this goes through this year where they repeal subsection 8, but they apply caps, then are they going to say next year, well, we're not going to talk to you about this until the OPAGA study is finished. And that's 2029. So we're not even going to bring up anything about this legislation until 2029. And that's why I feel such pressure to get them to understand all of this session.
Yeah, but see, that should not be a reason to stop the people's voices from being heard and directing their representatives from changing the law, is that a study is being done. What if they chose a study for 30 years?
And they could, but I can also see them saying, we heard your voice. We've put a process in place to study this. And, in 2029, we'll have our answer.
Well, then you say, well, we've changed our voice. We're speaking louder now. You're there to change laws, change the laws.
Yeah, and that's how I feel. I mean, I started off with a clip of Yarborough saying this is an injustice. Okay, then cure the injustice. How about you do this? Repeal subsection 8, spend from now until December 31st, 2029, doing your research, and in 2029, determine whether or not you need to put caps on it. Why don't we do it that way? Instead of applying the caps now and then waiting to see if anything happened. Because we've had 34 years of knowing that subsection 8 didn't do anything. It didn't cure your problem that you said you had back then. So why don't we do it the other way now?
Yep, they got a lot of data to already sift through.
Yeah.
Go through that and make a wiser decision in the future.
That's right. Why don't you leave your caps off now? And then in 2029, if you decide that caps are necessary, it's instead of always putting the burden on the people, it's always the people who have to suffer.
Yeah, while they're getting rid of caps, take them off of the fines that they assess the medical industry.
Yeah. We should do a podcast on your feedback system that you've come up with and talk about that. Maybe people could listen to that and have something to suggest to their legislators. The people took one for the team back in 1990, and I think now the legislature owes them an apology. Get rid of subsection 8. As Senator Yarborough and others have said, it was an injustice. So let's get rid of it and now start your study. And if your study says that caps are an absolute necessary, then apply those. But don't put the caps on us now and then try to figure it out. You did that in 1990 and it was a miserable failure. So unless you had any other comments, Travis.
No, I would just like to see the test the Supreme Court uses corrected.
Yeah.
Such that the law takes into effect the causality.
Yeah. Do you think the little video that I played will help people understand the difference between rational basis and strict scrutiny?
It should. If not, there's no hope. But no, it should help people understand it.
Well, I know you've heard me use this example before, so bear with me, but I think it's a good example for people to understand how something could be rationally related. Let's say that your government wrote a law, your legislature wrote a law that said you can't grow a vegetable garden in your backyard, and you challenged the law. And the court looked at it. First, they showed deference to the legislature and said, well, we're going to trust that what they did was, they had a rationally related reason for that. And they came up with the idea that if you grow tomatoes in your backyard, you're not buying tomatoes at the local grocery store because you're growing your own. Therefore, it's rationally related to commerce that your grocery store is going to go out of business if too many people start growing their own tomatoes. So the government has a rationally related interest in telling you not to grow, you can't grow tomatoes. I know that's a very simplistic way of looking at it, but basically that's what it comes down to. They can come up with anything that's rationally related. Some people have used the example that even the court, if a justice could come up with a way that it's rationally related, they don't question the legislature, they just defer to them. And as Professor Barnett says, why should they get two bites at the apple? We're supposed to have a court there to question when laws are unconstitutional, but when that court is deferring back to the legislature, saying, well, if you wrote it, then it must be constitutional, don't take up our time. But people need to get involved in this stuff and learn about how all this works, and then utilize the way our system is designed to get legislators to understand how to solve problems. But anyway, well, thanks for joining us. Travis, if you don't have anything else to say,
Like, subscribe, ring the bell.
Like, subscribe, tell everybody to like and subscribe. And tell your friends about us. Everyone have a good day.